Hello everyone, my name is Dr. Swati Singh. I'm Assistant Professor, PCJ School of Management, Maharaja Agrawal University. Today I'm going to talk about Indian Contract Act 1872. We'll be discussing the introduction part, definitions and essential elements of valid contract. First of all, talking about introduction part, law of contract is a branch of mercantile law. This act deals with the laws governing all the contracts. Law of contract is applicable not only to various kind of business and commercial activities, but also to personal dealings. For example, you're purchasing certain items from your vendors, you enter into a contract with that particular vendor. Indian Contract Act, which was passed on 25th April 1872, came into effect from 1st September 1872. Now we are going to discuss some of the important definitions that has been given in Indian Contract Act. First of all, definition of contract. Defined under Section 2, subsection H, a contract is an agreement creating and defining the obligations between the parties given by Salmon. Every agreement and promise enforceable at law is a contract. This definition has been given by Sir Frederick Pollock. Agreement has been defined under Section 2, subsection E of Contract Act. It has been defined as every promise and every set of promises forming the consideration for each other. Agreement will be equal to offer plus acceptance, which means to form an agreement there has to be an offer and that offer has to be accepted. There must be at least two parties to agreement where one party will be making an offer and other will be accepting that offer. Definition of promise. According to Section 2B of Contract Act, a proposal when accepted becomes promise. In this current slide, we are going to answer what is an enforceability of agreement. An agreement is said to be enforceable by law if it creates some legal obligation between the parties. The parties to agreement, they must bond to perform promises they have made to each other, and in case of default, they can sue each other. For example, if A offers to sell his car to B for rupees 3 lakh, B accepts this offer, such agreement between A and B will become a contract because here it creates a legal obligation, and if any of the party refuses to honor the contract, the other party can file a case. In case of social and domestic agreements, the usual presumption is that the parties do not intend to create such kind of legal obligation. So this enforceability of agreement will not be applicable in case of social and domestic agreements. This is an important landmark case that we discuss in case of social and domestic agreements, Walfer versus Walfer 1919. A husband and wife, they were resident in Ceylon, where husband was working. They went to England on 9-month leave, and at the end of the leave, the husband has to return and the wife was advised to remain in England due to her illness. Mr. Walfer, he promised to send her monthly allowance of €30 until she returns to Ceylon. Mr. Walfer, he failed to pay the amount, and here the wife sued him for the allowance. It was held as there was no intention to create legal obligation. She could not recover as it was a social agreement and parties were not intended to create any kind of legal relationship. The current slide will help you understand these concepts and definitions more easily. It is said all contracts are agreements, but all agreements are not contract. Talking about proposal or an offer, when accepted, becomes a promise, and when promises are made in such a way that it forms consideration for each other, it forms an agreement. When a particular agreement is enforceable at court of law, it becomes a contract. How agreement becomes a contract? If an agreement fulfill all the conditions of section 10 of the Act, then it becomes contract. It means there has to be fulfillment of 10 essential elements to become an agreement into a contract. Essential elements of valid contract has been mentioned under section 10 of Indian Contract Act. In order to find out or determine whether an agreement is a contract or not, we have to find out whether all the essential elements as mentioned in Indian Contract Act are present in the agreement or not. The first important essential element of a valid contract is offer and acceptance. There must be at least two parties in the contract where one party will be making an offer and other party will be giving its acceptance. No contract or valid contract can be there if there is no offer. So we can say that offer is the starting point of a contract. Intention to create legal relationship. Whenever parties are entering into a contract, their intention must be to create legal binding or legal relationship. In case of all the social and domestic relationships, this particular element, that is intention to create legal relationship, will be absent. For example, in case of business contract or commercial contracts, there is intention to create legal relationship. So if either of the party do not perform their promises, respective promises, the other party can sue them. Next is free consent. Talking about the free consent, in contract, one party makes the offer, the other party accept that particular offer. So in case of this contract, the acceptance must be free, it must not be forced, or it should not be under any threat. The consent given by the party should be free, should be genuine and true. Next is capacities of the party. When the parties are entering into a contract, the capacities of parties determine whether a particular person is capable of entering into a contract or not. The capacities of parties has already been defined in Indian Contract Act. The person who has attained the age of maturity, the person who is of sound mind, and the person who has not been disqualified under any act can or they are capable of entering into a contract. Lawful consideration. Lawful consideration means something in return. So whenever the parties are entering into a contract, the contract will include reciprocal set of promises where both parties will be making promises to each other. So consideration is very necessary. So consideration has to be lawful and it should be having some commercial value. For example, A party makes a contract with B party where A will be selling his house to B worth 50 lakh rupees. When A transfer the property to B, B will be getting that house and in return B will be giving 50 lakh rupees to A. both will be receiving consideration. This is known as lawful consideration. Lawful object. Every agreement that has been made, it is made with some objective, with some purpose. The object of entering into a contract or agreement should not be illegal. It should not be opposed to any kind of public policy. So we can say whenever a contract has been entered or agreement has been made, the object of agreement should be lawful. For example, A is making a promise to kill B for some cash. This kind of contract will not be a valid contract because killing of a person is a kind of punishable act under IPC. Therefore, this kind of promise is unlawful and void. Agreements not declared void. Agreements must not be expressly declared void or illegal. So if any certain agreement has been expressly declared to be void by law of a particular country, then such agreement, if entered by any person, they shall not be enforceable by court. When contract or agreements are made, there are certain terms and conditions which are mutually decided by the parties. These terms and conditions which are included in the agreement, they must be certain, they must not be unambiguous. It must be unambiguous. If the terms of agreement are uncertain, it will surely be not a valid contract. Possibilities of performance. When parties make an agreement, it contains reciprocal promises made by parties to each other. So these promises under the contract must be possible to perform. If the parties have agreed on the contract which contain any promise not possible to perform in real life, the contract will not be considered as a valid contract. For example, if a party is making a promise to bring back the life of the dead, such kind of act is not possible in real life. So these agreement will be void because it is impossible to perform such agreement or such promise. There are a number of legal formalities that has to be performed. There are certain cases where document has to be stamped, it has to be registered. So when it is mandatory to get it registered or the contract should be in writing, then the required formalities has to be fulfilled in order to complete that particular contract. So these are important essential elements of a valid contract which will make the agreement a contract. Now we are going to differentiate between agreement and contract. First of all, on the basis of definition, section 2 subsection E of the Contract Act defines agreement as every promise and every set of promise forming the consideration for each other. On the other hand, in contract, the contract has been defined under section 2 subsection H as agreement enforceable by law is a contract. The second basis of difference, when one person offers to another to do or not to do certain act and the other party accepts it is an agreement. Whereas an agreement which creates legal obligation is a contract. Offer and its acceptance forms an agreement, whereas agreement and its enforceability creates a contract. Agreement may not create a legal obligation, whereas a contract necessarily creates a legal obligation. In case of breach of an agreement, no damages are awarded, whereas in case of breach of contract, the damages are always awarded. Agreement is not concluded or a binding, whereas contract is concluded and is a binding. Thank you so much. This was all about Indian Contract Act 1872. We only included the introduction part where we covered the definition and essential elements and the difference between agreement and contract. Thank you so much.